Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
You're listening to Serious Privacy, powered by TrustArc. Here are your hosts, Paul Breitbart, Ralph O'Brien, and Dr. Kay Royal.
After 2 weeks of IAPP updates and a little bit weak in privacy, it's back to normal as of today. And it's back to the old days because Ralph is not here with us. So it's just Kay and myself talking about the smaller things that have happened in recent weeks. Some of them maybe not so small, but major news maybe we also do not have. In any case, my name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So this is Retro Week. I love it. Okay. Unexpected question. If the company had a mascot, what would it be and why? And this is the Serious Privacy Company. If we had a mascot, what would it be and why? And no, I hadn't thought about this either.
The obvious thing would be a pink and blue microphone.
Clearly, we need to do something with pink and blue, right?
Because that is also part of our stickers and all of that. But given your fondness for all kind of cuddly toys during the IAPP conference, I would say it needs to be a pink and blue cuddly toy. And what kind of animal? That's up for grabs. Maybe, I don't know. Didn't see anybody doing a giraffe yet, so maybe a giraffe?
A giraffe. I think a giraffe would be perfect. We can't do a dolphin.
Or maybe a zebra?
Maybe a zebra, maybe a jaguar. I'm thinking of something that has spots or stripes.
Mm-hmm.
Zebra might work.
A Dalmatian.
A Dalmatian. Zebras and Dalmatians are all very unique. I don't know. I guess giraffes are too, aren't they? None of their stripes are exactly duplicative of each other. They're unique for each one. Okay, so any of those would work. Okay, fans, we may put this out to a vote, and who knows, we may do stuffed animals. We can't carry stuffed animals. No, that might not happen. But yeah, okay.
I have no idea how to carry stuffed animals across the border and dealing with tariffs and all of that. We'll see.
It may have to be miniature keychains, might be all I can do to begin. We'll see what those are. Okay, beautiful. I just thought that was a fun one. And when it popped up, let's talk a little bit about what's happening in privacy. And funny enough, I think the first thing I mentioned to Paul when we got on today was he does realize that one of our former podcast guests is now the head of the California Privacy Protection Agency, Tom Kemp.
And I did not realize that. I had seen it when the press release was put out, but had forgotten about it already. So yes, congratulations to Tom Kemp.
Yes.
Episode is still available for a listen, talking about his book. And I think it's always good if people who are well conversed in the topic are also going into the supervisory roles.
So California fined Todd Snyder. It's a clothing retailer. I don't know what brands are under it. I can look that up and see if it comes out. But what they fined them for was $345,000, so not small. But they found or alleged that they violated privacy rights by, one, failing to oversee and configure their technical infrastructure of the privacy portal, which resulted in a failure to process consumer requests to opt out of the sale or sharing of personal information. Now, sharing is uniquely a California thing, so keep that in mind. But they also required consumers to submit more information than necessary to process their privacy request, which is very closely related to the third one, requiring consumers to verify their identity before they can opt out of the sale or sharing of their personal information. Now, Paul, you and I have talked about this before. This is the opt-outs that are automatically from the trackers online, and people want to click do not share my information or do not sell it. And companies are requesting them, well, who are you? Prove your verification, prove your identity, do this, do that. Well, when they're tracking you by something automatic on your computer, they didn't have your identity and verification in order to opt you in. So they shouldn't need it to opt you out.
Exactly.
This is a conundrum that companies are wrestling with, because how do you opt someone out electronically? And we've discussed California is a little bit weird in requiring the global privacy control, which is another reiteration of the do not track mechanism that never worked. And I'm afraid that they're going to find that this global privacy control doesn't really work either for what we would like it to do. But meanwhile, companies are being faced with this conundrum of they track people automatically without getting identity, but you have to opt them out just as easily as you put them into it. So that's gonna be bad. So this means that there was no guilt found or anything. It was a settlement. So Todd Snyder agreed to pay the fine. They'll change their business practices.
So probably they also realized that what they were doing was not completely in line with the law.
Exactly. The head of the CCPA's enforcement said businesses should scrutinize their privacy management solutions to ensure they comply with the law and work as they're intended, because the buck stops with the businesses that use them. Using a consent management platform does not get you off the hook for compliance.
No, also because those can be configured in ways that are all wrong.
Yep.
And we have seen that before on this side of the Atlantic with the IAB's transparency and consent framework, which was found to be non-compliant with the GDPR and the cookie directives, price. And also there, the fact that it's part of a consent management tool that or platform that doesn't mean indeed that it's automatically compliant. And also for the vendors of these CMPs, yes, I would encourage all of them to build their tools as much compliant as possible. At the same time, there are a gazillion configurations also depending on the various countries.
Yeah.
And also guidelines per country, even within the European Union, because this is not something that's fully harmonized yet.
Exactly.
So it can be hard to be compliant by default when using a CMP. So it is your responsibility as an organization to really look into that. And in part, for most organizations, that will also be a business decision involving what can I get away with?
Yeah. Although they might not frame it that way.
No, of course they wouldn't.
Generally what goes through their minds, right? So California also listed some things that they have up to lately. So we might as well share a little bit of that too. You can also read it in their press release online. A decision regarding Honda Motor Company, which was a $632,000 fine. It was the second highest in their history. Securing a settlement agreement requiring Background Alert, who's a data broker, promoted its ability to dig up scary amounts of information about people. They had to shut down or pay a fine. Enforcement action against National Public Data Inc., the Florida-based data broker, for a breach. Launching bipartisan consortium of privacy regulators to try to get people around to talk, and partnering with the DPA authorities in Korea, France, and the United Kingdom to share information about privacy protections for Californians. They've also had other enforcement actions. They had an investigative sweep of data brokers' compliance with the Delete Act, different things like that. So a little bit going on in California, not surprising. They're the oldest and the only actual privacy regulator in designated specifically as an agency to be the privacy regulator.
No, that's absolutely true. California is the one specific privacy protection agency in the US that is up and running. Just for the sake of the thought process, say South Carolina adopts a data protection law similar to CCPA, and they ask you to be the chair of an independent South Carolina data protection agency, privacy protection agency.
Pay me enough to make a living and I'm there. Yes.
What's your first priority?
Oh, there you go. It would have to be the same thing I would do coming into a company. You have to survey the landscape. What exactly is happening in South Carolina? What have the priorities be? Have there been any deceptive and unfair trade practices, investigations? Do we have data brokers here? There's data brokers everywhere. So it would be a survey of what is the state of South Carolina privacy. That's the first thing. And then after that, we hate data brokers. We hate data brokers. We love consent. We want practical privacy protection. So it would be making sure, I'm assuming they wouldn't set up an agency without actually having a law. So a lot of it's going to be based on the law, which maybe I should try to figure out who in South Carolina is working on a privacy law, because that would be interesting.
If anybody.
There is one, it says in committee.
Okay.
So if we go to the IAPP's privacy legislation tracker for 2025, there are Washington, New Mexico, Mississippi, Alabama, South Carolina, Illinois, Pennsylvania, New York, Maine, and Massachusetts that have privacy laws in committee. And you know what? I'm actually going to follow up on that and see what the heck South Carolina is doing. Inactive in only 3. So West Virginia, Arkansas, and Georgia are inactive. In Cross Chamber is just 1. Vermont, I have not looked into these state laws in detail because in the first quarter of the year, everything's just a flurry and going crazy. In Cross Committee is Oklahoma. So that's really interesting. I heard that Montana had one, but Montana already had one. Someone just asked me a question about a new law that was being passed, and I swear it was Montana, but Montana already had a privacy law.
Maybe they only just became aware.
Might be they didn't realize because it's coming in effect. Okay, so we'll look at that. So those are the privacy laws you have. I'll look into South Carolina and report back if there's anything. Maybe I can insert myself into the process.
Who knows?
They may not want me to.
Kay Royal, chairperson of the South Carolina Privacy Protection Agency. So that would be the SCPPA.
SC Discipline. We can do with Discipline. I like it. Okay. What else have we got going on? If we're here in the U.S., let's look and see what else we've got going on in the U.S. I know you found a few things as well. California is seeking public feedback on proposed regulations for the delete, request, and opt-out platform. They call it the DROP system. That has to be a backronym. The DROP, that's cool. But they need it by June 10th. So people, get busy. Give comments. Let's see what else we have. As we mentioned, the CPPA in the UK, ICO, signed a declaration of cooperation on enhancing international privacy and data protection coordination between jurisdictions. As we know, California was already recognized as adequate under the Dubai International Financial Center. Michigan, the Attorney General sued Roku for violating COPPA by collecting and allowing third parties to collect children's information, including location, voice recordings, and browsing history trackers, which, by the way, that's becoming a big thing in the U.S. And kind of like you have patent trolls. Now you've got browser history tracker trolls going on as well, which if you're any one of those, just stop. We don't need trolls for that. We're trying to do the best we can. But let's see what else we got. Without parental consent, it states Roku enables third-party collection for advertising. And also, these are trackers on a website that should be directed towards children. A defense to that is a general use website. But frankly, people, if you know you got stuff children want, Roku would have things that children want. Pay a lot more attention to protecting children. Let's see. And then New York, there's a class action lawsuit settlement against Somnia, which had a 2022 data breach, which includes a lot of information. The updated COPPA rule was published in the Federal Register. This has been 6 years of getting this point. I swear to God, every 3 or 4 months, I'm looking at Paul going, hadn't they passed this thing yet? Apparently, they're getting there. The chairman of the House Committee on Energy and Commerce and the Subcommittee on Commerce, Manufacturing, and Trade, with 10 subcommittee members, sent a letter to DeepSeek reprimanding them, basically raising concerns that they have about its practices. So more on DeepSeek. Oregon Department of Justice Privacy Unit has reported a significant increase in complaints for the first quarter of 2025. No surprise, it just went into effect there. And so more complaints there. But it's interesting that people are actually submitting a lot of complaints. And in Washington, the district court approved a class action lawsuit settlement concerning PillPack related to soliciting non-emergency telemarketing calls promoting goods and services without consent. That violates the Telephone Consumer Protection Act. The company denies it, but they agreed to pay $6.5 million into the settlement fund. Methinks, my lady, that's protest too much. Since 0.5 is not just a small drop. But there we go. Let's look at Canada. So Quebec's Access to Information Commission and Alberta's Privacy Commission reminds Canadians that 23andMe does not have good protections, that you should opt out of it and you should request that your data be deleted.
Maybe a little bit too little, too late?
Too little, too late, right?
Similar to the letter that the ICO and the Office of the Federal Commissioner in Canada sent to 23andMe saying, hey, you should be careful now that you are bankrupt and dealing with your data. Also, that is maybe a little bit too little, too late.
It might be. And I tend to take it as a standard thing to add into the privacy notice because bankruptcy is generally not covered. You might want to put in there that if for some reason the company is sold or goes out of business or has court filings, that the data may be considered an asset and may be taken into custody by the court or a designated custodian.
Yeah, but under GDPR, they could not just be sold off because it can very well be that also involves a change of purpose.
Exactly.
Which may require consent. That is also why data protection lawyers always need to be involved in investment rounds and M&A processes.
Yes. And by the way, if you own two companies, you can't just share the data willy-nilly between two companies.
No.
Just because you own them both and you got permission.
Unless the data is owned by a group and the two companies are part of the group.
No, that's true. This is like kids, go ask your mom if you could do something. Nope, sorry, go ask your dad. No, that doesn't work. It really doesn't work. You need to have that documented and in compliance.
Both Mama Kay and Daddy Paul say no? Is that what you're trying to say here?
Exactly. Go ask Mama Kay. No, go ask Papa Paul.
Over to Europe. Belgium has a new data protection law. They have updated the implementation of the GDPR, mainly to clarify some rules regarding to the appointment of the members of the supervisory authority. And that also meant that now that the law has entered into effect, that the supervisory authority, at least the committee of directors, had to be recreated. Most of the previous members have been reappointed, but there is a new chair, and that position was also vacant. Koen Gorissen of Flanders, he is now the head of the General Secretariat of the Data Protection Authority, and therefore also the chair of the authority for the next 6 years.
Nice.
He has a long background also with the predecessor of the current Data Protection Authority, and I actually used to work with him on a couple of files in my days at the Dutch DPA. So congratulations to Koen and to the Belgian DPA in general. Then we have the European Data Protection Board. They met on the 5th of May and have released a press release. I don't believe It was a very exciting meeting, at least from the press release. There is not a lot that was published. It was actually one thing that was published is that the EDPB presented their opinions on two adequacy decisions, one for the European Patent Office, where the adequacy decision was approved. The other one is the extension for UK adequacy that is suggested or requested by the European Commission.
Right.
We all know UK adequacy expires in June if nothing happens, because then the 4 years since the initial decision are up. But the UK is also still in the process of updating their data protection law. The bill is now back in the House in an updated version as of today, but the process has not been finalized. So in the interim, the Commission has said then we'll extend adequacy by 6 months. The European Data Protection Board has said that's okay, but we only do this once, no further extensions. So if the legislative process is not done in time this expires, but we will not do this again.
Too late, so sad.
Yes. So the UK better make some haste in updating their data protection law. Speaking on the European Data Protection Board, the EU General Court has thrown out a case that was raised by Meta. Meta has obviously concerns about the EDPB's position on consent or pay.
Obviously.
So the new advertising model where you have to see personalized advertising unless you subscribe to Facebook or Instagram and pay a fee for that. The European Data Protection Board has said that is not allowed in a set of extensive guidelines that were published last year. And Meta has said, we don't like this. This goes against our business model, our freedom to do business. So they challenged the opinion in court and said, no, this should be revoked. This should be repealed. This should be annulled. It should be crushed. Whatever the court can do, please get rid of it. And the court has says, no, we're not going to do that because this is not a final decision that can be challenged in court. Opinions of the European Data Protection Board are what they say they are, what it says on the package. They are an opinion. And it's the opinion of the joint data protection authorities, how they interpret the legislation, but they're not binding on the general public. They are very relevant for the general public because it will show the line of thinking of supervisory authorities when they are dealing with a specific case. But it doesn't mean that they are binding. DPAs can also deviate from decisions of the board or its predecessor, the Working Party 29. We've also seen that with the Dutch DPA deviating on legitimate interests. Of course, that was also set right by the court, but still, this is not a binding interpretation of the law, and therefore, companies like Meta cannot get decisions of the EDPB annulled in court, which is only rightfully so.
That kind of sounds like two things. One, it sounds like people who object to your privacy notice. Your privacy notice is telling you the privacy notice. You don't get to object to it.
Nor do you get to consent to it.
You don't consent to it. It's a notice. But the other image is right along with our theme today is like your parents tell you to do something and you say, no. Can't you just see the child sitting there saying, no, don't like this, no.
Yeah, you are still going to do it. That's also the final conclusion. And basically, the court says Meta can challenge any final decisions from data protection authorities back in court, but you cannot just challenge the EDPB because you don't like their decision.
I got a question on this, a legit question. European lawyers and companies know you can't challenge an opinion. Do y'all see that happen very often? Is this just the arrogant American company trying to do it? Or legitimately have companies tried to challenge opinions before?
Not that I'm aware of. I'm not sure whether this is an arrogant American thing. I actually think it's probably for the best that somebody at some point challenge whether or not the EDPB opinions are binding or not. Everybody always assumed they are not, and that they are the interpretation of the DPAs that are mainly aimed at themselves and not at the general public.
Nice. So it's a de novo challenge. You're asking them to look at a new point in law. Can the opinion be challenged? Interesting. Okay.
Yeah, I don't believe that was Meta's intent, but that is what it became.
So say, I take back my arrogant American thing there, but as we've discussed, Americans are much more litigious than I think any other country on the face of the earth. And so we think we can argue everything. And I'm not talking about Meta in particular. I'm talking about we think when it comes to law, we're the Wild West. We can argue every point, the placement of a comma, whether there's an A, an, or the. And in Europe, as GDPR was coming in active, this is one of the bigger conversations that I had with people was Europe laws say what they say and mean what they say. There's not much argument there.
Yes and no. For the GDPR, that's exactly one of the problems because GDPR was written to be technologically neutral and future-proof.
And therefore vague.
There are a lot of open norms and they require interpretation, and that needs to be done by a lower level quasi-legislator. So it's not the legislator themselves who can interpret the legislation, because then the Commission, the Parliament, and the Council together would need to issue a statement and first of all agree on that.
Yeah.
So they probably also like the ambiguity. And that is what the data protection authorities, as part of their mandate, should be doing, is interpret the legislation and how it applies in day-to-day situations. And that is also why already the Working Party 29 started developing those opinions with examples, with guidance on how they, as authorities, would look at the interpretation of the law to ensure that there was some sort of consistency and harmonization across EU member states to ensure that both data subjects and companies have a level playing field.
Yeah, clear expectations as well. So y'all don't blame it on these arrogant Americans for challenging every rule of law there, although sometimes we do go overboard.
There is some other news, and that's also pretty big. TikTok was fined 530 million euros. We expected 500. It became slightly more.
Which is unusual.
For the transfers to China. And for me, that is not the actual news. The actual news is that this decision went through the consistency mechanism and none of the data protection authorities had comments.
Ooh.
It was adopted in one go, even though it was an Irish decision. So I guess the Irish have either learned from previous cases or was already adjusted ahead of time, making sure that other authorities gave their input and that everybody was aligned.
Yeah, because we've seen and talked about when they're not aligned and what happens.
Exactly. The thing is here that ByteDance, the mother company of TikTok, people at their headquarters have access to data of European users of the app. And ByteDance is not able to show that they have the right level of protection in China. For example, that there is no government access. They claim there is not, but they are not able to actually demonstrate that in full detail. And also they do not inform people sufficiently that their data will be going to China. So that is very relevant. That's very relevant information. So it's both about the transparency, but also about the fact that not a sufficient level of data protection was offered. And the stupid thing is that as part of the disclosure of documentation during this whole case, apparently ByteDance also actually showed documents that made clear that data was actually going to China, what they had originally denied.
Interesting.
So the Irish DPC says on their website, throughout the inquiry, TikTok informed the Commission that it did not store EEA user data on servers located in China. However, in April 25, TikTok informed the DPC of an issue that it had discovered in February 25, where limited EEA user data had in fact been stored on servers in China, contrary to what they had evidenced before. This will lead to a further investigation from the Irish Data Protection Commission and possibly also a further fine.
So one of the personal things I had happen is I have a pageant coming up. And so I reached out to the current queen. I'm like, I like the videos that you do for social media and I'm looking for an easy tool to use. What do you use? And she said, CapCut. I don't just go to CapCut, download CapCut. I have to look and see who CapCut is. They're owned by ByteDance.
So very user-friendly, but not very user-friendly.
Exactly. So I had to write her and say, oh, goodness, thank you. I won't be able to use that one because they're owned by ByteDance, the company that owns TikTok. And I can't do that for privacy and security reasons.
Did she respond?
She was not very sympathetic. It tells you it's not the ennui, but the apathy that the average users have for TikTok or anything that ByteDance owns or anything. It doesn't impinge on them, right? They care about it perhaps from a professional viewpoint, but they don't care about it in their daily lives. And I need to wake up and smell the coffee.
As long as they can afford the coffee.
That is true. That is true. But the price is much more than you actually pay. We all know it's free because you're the product. And that's a high price to pay. But okay, what else you got going on? You have some pretty cool things. Like you said, no big earth-shattering things, but some pretty cool things.
There is one more from France where the CNIL has offered guidance on cameras at self-checkout registers in shops.
Yes.
We see this happen more and more. It's also heavily criticized. And the CNIL has said, in any case, you cannot be forced to go through these registers which have cameras to record what you are doing. You need to be presented with opt-out possibilities. You need to be provided with proper notice on screen at the terminal if you do choose to use one of these. And there should also be ways to have the information A, removed, but also B, not used for training the algorithm that further decides whether or not you are trustworthy or not. So it's all very basic data protection law. At the same time, It is, I assume, fairly complex to implement in these machines because obviously they were not built with privacy by design in mind, let alone privacy by default, because otherwise the camera would not even be there.
Wouldn't, yeah, exactly. So why do you need cameras on the self-checkout? I get it, the companies, but really, how much are you saving yourselves? if you have a problem with people checking out and not scanning all their items, how much are you losing?
That's quite a bit. It's a couple of dozen million per supermarket chain here in the Netherlands on an annual basis. It is quite a lot. At the same time, if you probably do more random checks and have somebody to supervise the self-scan registers, that might help.
They could put eyes up. Eyes have been proving in studies to stop people from doing illegal or nefarious things. So put eyes up.
Exactly.
If they think
But staff
people are
is, of
watching.
course, also a problem. Getting sufficient staff is a challenge. And also, these cameras do not solve the self-scanning with your phone or with a handheld device that you can pick up in the supermarket to scan all your groceries and then go to the self-checkout, because then it's just what you have scanned already. So also there, random checks are the only way to double check to see what is happening. So yeah, on that note, I think we can wrap up for this week. That's all the news we have. Next week, we dive back into IAPP for one more episode. So stay tuned.
One more episode. But this is not an IAPP episode, people. I'm warning you. This is an episode on Indigenous privacy. We just happened to get all the people together at IAPP. So we're excited about that.
Stay tuned.
That was Serious Privacy.
This wraps up our podcast for this week. Please do share the episode with your friends and colleagues, because we love to get more listeners. And join the conversation on LinkedIn or on Blue Sky. You'll find us under Serious Privacy on both platforms. You'll find Kay as Heart of Privacy, Ralph as IGR O'Brien, and myself as Europol B. Until next week, goodbye.
Goodbye.
Bye, y'all.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on Nimity research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.